This is Barry Zalma, Zalma on Insurance. I'm an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author and producer of these videos. Today it's time to talk about the April 15, 2021 issue of Zalma's insurance fraud letter. And one of the articles in that letter is the one that describes two types of soft fraud that are ignored by regulators and prosecutors. The first is called good cause fraud. Morally and criminally, insurance fraud is always wrongful. Many people within the insurance industry and outside it believe because insurers are so well funded that there are good causes for committing insurance fraud. A frightening trend is emerging where judges, jurors, and administrative law courts are refusing to convict or hold responsible perpetrators of fraud if the court is convinced that the fraud is for a good cause. Good cause fraud is believed to be benign. A version of soft fraud, it is justified in the minds of jurors and judges who should recognize it as no less a crime than fraud for the sole reason of gaining profit. The same people would never justify the robbing of a bank or a convenience store for a good cause. It is, however, no less a tort or a crime. The true trier of fact, the judge or jury, convinced of the good cause, will simply refuse to punish the perpetrators. Fraud for a good cause is just as wrong in the eyes of the law as fraud for an evil cause. Justice will fail if the subjective intent of the criminal becomes a defense. This is supremely true in the case of good cause insurance fraud. Everyone who cheats an insurance company, except the most dedicated and professional fraudsters, believe that they are doing so for a good cause, and that no one is being harmed. It is a fact, however, that soft fraud costs the insurers more every year than major fraud rings. If the usually honest can be made to fear fraud prosecution, more money will be saved than by imprisoning a few hardened insurance criminals. In addition to good cause fraud, there is the, quote, we all do it fraud. The California Court of Appeal, for example, in a case called Qasim versus Allstate, a 2004 decision of the California Supreme Court, faced with a trial verdict of bad faith against an insurer that it found was based upon final argument leading the jury to believe that some fraud is permissible. The argument for the insured who committed the little bit of fraud follows. Quote, Plaintiff's counsel, now let's talk about intentional misrepresentation for a second. I think we have a direct analogy to what goes on in this case. Let's think of this for a second, if you would. Just think. You're at a job. You've worked at it real hard. You're a good employee. And then a new boss comes along. He doesn't like you. Maybe it's because of your sex, your race, or whatever. And he discharges you. And he wrongfully discharged you, and you go get a lawyer and sue for wrongful discharge. And your employer does what Allstate has done here, is they look under every rock you were ever under, look at every skeleton, everything in your life they can use. And they go and they do a check and they say, "Ooh, you were on jury duty in a case called Castle." Okay. And they say you were supposed to be on jury duty, but there's a couple days in which there wasn't court. But you said you were on jury duty and we paid you. That's a misrepresentation. Defense counsel objected as improper argument, and the court overruled the objection. And so plaintiff's counsel went on. And they will take something, like Allstate has done here, the mortgage file, or whatever. It's even worse, what they've done here, and say we have grounds now to fire you because you misrepresented about your being on jury duty on certain days and you got paid when you really weren't. And you say, but Judge Chernus said it was okay. He says what I was doing was appropriate. And he says, no, you intentionally misrepresented. I didn't misrepresent anything. I thought that was the right thing to do. She said I didn't misrepresent anything. I was relying on Tony Thompson. I thought it was the right thing to do. I didn't intend to fool anyone. And your whole career, bang, you're out. Isn't that what they've done here? They want to put an artificial standard on what is meant by intentional misrepresentation, a standard that would apply in a courtroom setting like this, that we would never apply to ourselves, that we would not think that anything was intentional or wrong in that regard. But in trying to carry their burden of proof, when they have this kinds of flimsy, crap evidence, when they haven't done what they should have done, and they're doing the lawyer's thing, they will have you now crucify these people with an extraordinary, artificial interpretation of what is intentional misrepresentation. And that's not fair. Close quote. The California Court of Appeal in Casem concluded that the argument was prejudicial and reversed the trial verdict that assessed punitive damages against the insurers, stating, quote, "Here in a case where fraud in an insurance claim was a primary issue in the case, counsel for plaintiff went right to the fact that the jurors had been essentially cheating their employers. When counsel made reference to the fact that some of the jurors might be accused of cheating, there was no question. He was letting the jurors know that the court had no objections to the procedure. When the objection was sustained, there was nothing else counsel could do except object again, which would have had the effect of drumming home to the jury that the court thought a little cheating was possible, since the issue was whether plaintiff had attempted to cheat in their claim to Allstate. The prejudice was obvious, and it was prejudicial." Close quote. The California Supreme Court, however, reversed in Casem v. Allstate, a 2004 decision concluding that assuming the insured's counsel committed misconduct in the closing argument, no prejudice resulted. The Supreme Court concluded, quote, "Considering the brevity and indirect nature of the challenged argument, together with the court's jury instruction explaining the meaning of an intentional misrepresentation and causing the jury not to take its cue from the trial court's actions or comments, the Supreme Court concluded that Herzog's argument referring to the trial court's direction, even if misconduct, did not result in a miscarriage of justice under Article 6, Section 13 of the California Constitution, because it is not reasonably probable that Allstate would have obtained a more favorable verdict in the absence of the argument, and the error was thus harmless. The law is still that an insured cannot commit a little fraud. A person either commits fraud or does not. A person cannot be a little dead. He's either dead or he's not. The law is still that an insured cannot commit fraud. The good cause for committing fraud, regardless of the insured's secret intent and belief that defrauding his insurer, he is doing a good thing. The law does not recognize a belief in rewarding Robin Hood, who allegedly stole from the rich to give to the poor, as an excuse for defrauding an insurer. In Cassim, the jury found that the insured did not commit fraud. If it had found otherwise, the insured, regardless of the bad faith of the insurer, would recover nothing. The concept of soft fraud is an oxymoron. If the tort or crime is committed, whether innocently or with malice aforethought, it is still fraud, since the perpetrator intended to deceive the insurer and in so doing cause damage to the insurer. The punishment must either be a lack of the benefits of the policy or a prison sentence or both. The insurance policy's concealment fraud clause unambiguously bars coverage for all insureds if any insured commits fraud or intentionally conceals or misrepresents a material fact. That provision will prevent an insured from recovering any benefits under the policy. Insurance fraud, even one done for self-help because of a failure of the insurer, is still a fraud. Applying Pennsylvania law, the Third Circuit Court of Appeal in a case called Dougherty v. Erie Insurance Company separately addressed an insured's attempt to assert a claim that the insurer's insured named Runk purportedly assigned to him. The appeal concerned one of Dougherty's attempts to represent Runk's interests more directly. In this case, Dougherty and Runk filed suit pro se, acting as their own attorney, and later filed an amended complaint, which, like all their other joint filings, appeared to have been prepared by Dougherty. The amended complaint is premised on a dispute between Runk and Erie Insurance Company regarding insurance claims that Runk submitted following an auto accident and on an apparently related Pennsylvania criminal proceeding in which Runk was being prosecuted for insurance fraud. Plaintiff named as defendants Erie Insurance, certain of its employees, the Cumberland County, Pennsylvania District Attorney, the Insurance Fraud Unit, and one of its investigators. The amended complaint is not a model of clarity, but plaintiffs appear to allege that Erie Insurance Company conspired with Cumberland County investigators to bring unfounded charges against Runk in order to coerce him into accepting an undervalued settlement of his claim, and that the Insurance Fraud Unit has denied him due process by conducting an inadequate investigation and by pressuring him to plead guilty to a legally impossible crime. The amended complaint requested $5 million in damages and injunctive relief, apparently against Runk's continued prosecution. Several defendants moved to dismiss the amended complaint on the ground it fails to state a claim, and that the purported assignment of Runk's claim against Erie Insurance to Dougherty is champertus, sharing the proceeds of litigation by one who agrees with either the party or defendant to help promote it or carry it on. The district court dismissed the amended complaint with prejudice for failure to state a claim, and then later denied by text only orders plaintiffs several post-judgment motions, including their motions for reconsideration, and to disqualify the district judge. In dismissing the amended complaint, the district court focused on Doherty and noted that Runk's purported assignment of the claim to Doherty appears to be champertus. That Third Circuit concluded that the assignment is indeed champertus. Doherty also does not have standing to challenge Runk's alleged denial of due process in his ongoing criminal proceeding. As for Runk, the district court did not identify his potential claims, but the Third Circuit did so, and agreed that the amended complaint does not set forth a plausible claim for relief. The style and content of plaintiffs' joint filings suggest they were prepared by Doherty, although Runk apparently has adopted them as his own by signing them. If Runk believes that he has a legitimate claim to assert in the future, he would be well advised to assert them without Doherty's assistance. Plaintiffs attached to the motion for a preliminary injunction of the Third Circuit the transcript of an August 28, 2014 hearing in Runk's criminal proceeding. At the hearing, the Cumberland County Chief Deputy District Attorney informed the court that Doherty, who was present in the courtroom, had been injecting himself in the case in filing motions, and that I am going to tell you right now he is under investigation for unauthorized practice of law. Mr. Runk is seriously in jeopardy from following his advice. Soft fraud is considered the form of insurance fraud that is most difficult to detect because soft fraud inherently involves a legitimate claim at its core. A perpetrator of soft fraud is not lying about the fact that items were stolen from him, for example. That is most certainly true, but he's lying about the item's worth or about exactly which items were stolen, sometimes even going so far as to say that certain items which he never actually owned were stolen. Soft fraud is also generally for smallish amounts of money, and the overall lie is not very large or easily detected. After all, if the item was stolen, there is no easy way to verify how much it was worth as a result of soft fraud. The rest of the newsletter, Zalma's Insurance Fraud Letter, covers an article that there can never be a fraud too small to void a policy, wisdom, good news from the Coalition Against Insurance Fraud, including an article on the fraud of the month, health insurance fraud convictions, other than health insurance fraud convictions, why a criminal must pay restitution to the victims of his crime, and why an insurance policy can be, and an insurer can be, a victim of an insurance fraud, just as its insureds are victims of crimes. And finally, it talks about some new books I have written and about my blog. If you found this video to be of interest, please refer it to your client. And please subscribe to Zalma's Insurance Fraud Letter, my YouTube channel, my Rumble channel, and my blog so that you can be advised of future videos. Thank you for your attention.